That was hello, chat. Well, that was a little weird earlier. I don't know. Did you guys see that where I'm just like standing here looking like a dumbass while the StreamYard thing catches up? Because that was really weird. That was really weird. Yes. Let's go again. Yes. Yes, chat. We are here to go again. Here we go again on our own. Going down the only road we've never known. And if you guys have noticed that formatting I have for the case with the red and yellow and the black and yellow, I did that for the Trump case. I tried to give it some sort of theme there. And yeah, I think this is a good wrap up to it. You know, doing the Trump Georgia cases. I mean, they're to the point where they deserve their own playlist now at this point. And I think it's very important to do that way. And we are going to get into what I think is the final chapter. And once again, this is not just for Fani Willis or Fani. You know, a defeat here, but a defeat in the YSL case. And I mean, just L after L after L after L after L coming our way. And this is actually a good tale of thanks for it's really something to be the issue of hubris, and Fani Willis was the epitome of it. And we're gonna get to this here. So let's get started, guys. If you guys are new, my name is Sean, also known as Potentially Criminal, attorney in the Cleveland, Ohio area. And tonight we are getting into the Fani Willis, the end of her saga in the Trump RICO case out of Georgia. Now, we got to go all the way back to the beginning. You guys remember going all the way back to 2020. And obviously, Trump did not win the election. And in multiple states, there were discussions and preparations of bringing slates of alternative electors to be available to vote for Trump should the Electoral College not work out the way the Democrats wanted it to. And we've seen these cases in, similar things where people have been charged in Michigan and in Nevada, in other places. And as we learned last week, the case in Michigan collapsed and was dismissed. The case in Arizona has been sent back to the grand jury and probably will also suffer a similar fate. The case in Nevada has also suffered a similar fate. And now the case in Georgia is going to suffer a similar fate. And before we get too far here, Corey Boatwright for 50 subs. Let's fucking go tonight, chat. Let's go. Thank you so much, Corey, for your support, your generosity. I mean, this is what this man is doing single-handedly to the Grays right now. He's doing his part. He's doing his part. Are you doing your part, chat? Are you doing your part? But anyways, Corey, thank you for your support and your generosity so very much. Very much. Thank you. And then Maddie B, who's been a member for 14 months. Thank you. It's a long time. Says, in honor of Fani, Rap Ho by Luda, please. Yes. Yes. Well, we'll get to Fani and all of her ho activities with ho tendencies. Because she did a lot of ho stuff in this case. Also, Dogsplained, right at the end of the show earlier, about a half hour ago, dropped a $50 super sticker. Thank you very much. But that kind of popped in. I didn't see it show up. It looks like it came on at the end. So thank you very much for that. I appreciate it. So you want to learn more? Yes. Halfway go to a second Factorio stream. You want to be a member? Do you take coupons? No. There are no coupons. It's like asking for coupons in a Christianity. No. There's nothing there but penance and suffering. You didn't intentionally avoid the attention. Well, thank you. Sorry. Angela says, not coupons. No, we're not for coupons. Anyways, Angela, good to see you. Thank you for being here. And real quick here, before we get too far, says, be quiet. A black woman is wasting taxpayer money. Yes. Yes, they are. Yes, they are. And then I didn't grease 1776. I think I messed that up here. I didn't greasy says, let's put Kirk on the $20 bill. Fuck Jackson or Tubman. Well, I like Andrew Jackson on there, so I kind of like having dead presidents. I want my dead presidents. The only presidents that, as the song goes, the only presidents that represent me are the dead presidents. So let's get to this, guys. So if you guys remember, Fani Willis charged 19 people in a sweeping indictment under the state of Georgia's RICO statute, just in the same way that YSL, Young Thug and the YSL crew, were charged. And in Georgia, two people committing a crime together is automatically RICO, which that's not how it works at the federal level. And that's not how it works in almost every other state. But Georgia has a really, really loosely defined version of organized criminal activity. And we ended up with if I got a book in the way, I can't see. We ended up. Also, who just texted me? Okay. We ended up with all kinds of problems here, and now we ended up with the Georgia election probe, and a lot of people are here. There's a bunch of names you guys probably don't remember, but we'll go through the ones you do know. Obviously, the Emperor of Mankind, Donald John Trump. Donald John Trump, the chairman of the Trump organization. Whoop-pow. Rudy Giuliani. And then people you may not know who are lesser knowns out there. John Eastman, who is one of the guys who came up with a lot of these legal theories. Mark Meadows, former chief of staff for Trump. Kenneth Chesebro, another attorney. Jeffrey Kark is one of the guys who was involved with, if they fired all the DOJ people, would he be getting involved? Another attorney. Jenna Ellis, another attorney. And then there's a bunch of people down here you may not know too well that really matter. And then finally you get down to Sidney Powell. This is the Kraken lady. So what happened from here? Well, as the case started progressing, Fani and the team started cutting deals with people. So people started cutting deals. So John Eastman cut a deal. Kenneth Chesebro cut a deal. Jenna Ellis cut a fucking deal. Sidney Powell cut a fucking deal. And they all cut deals to save their ass. Now, what was in those deals? Those deals, they all got basically probation and deferred. A couple of them even got deferred adjudications, meaning they can get this dismissed off their record, which, once again, for claiming these people subverted and destroyed democracy, and you're going to let them walk away with no charges at the end of the day? That's insane, because they're the ones they're the architects of it. They're the lawyers. They created all this shit. So yeah, these guys are gone. Done, and done. So that left everybody else fighting the court. And what did we learn? That Fani, guess those hoes ain't loyal. Those hoes weren't loyal. So those hoes were not loyal. Now from here, the rest of the team challenged Fani Willis. That she have the authority to do this? Did she present it properly? Did she follow all the rules as a prosecutor? And then we learned from one of the more investigative attorneys in the area, Ashley Merchant. You guys saw her in the YSL trial when Brian Steele was being held in contempt. And appears to be a friend of Phil Holloway. Guys, you see him over on Laid Back Law once in a while. Ashley Merchant, she showed up with receipts. And she started hunting. And as if you guys have seen any interviews of her, she started filing FOIAs as she represented a party. And this is Ashley Merkett, if you guys don't remember her. She showed up and started filing FOIAs on things at Fani Willis's office. And what did we learn? Well, that's where we learned about this guy, Nathan Wade. Remember him? You know, and what did we learn? He got paid shitloads of money to do nothing. And then what did he do with all that money? Well, it turns out that him and Fani Willis were bumping uglies. And they went on vacations together while they were sucking up money used for the Trump case. You know, all kinds of dollar bills. And that's Fani Willis, guys, if you don't remember. That's her. And we had hearing after hearing after hearing after hearing about this stuff. And it was ongoing. And Fani Willis even took the stand in her own defense and went up there and started arguing. If you guys don't remember, Fani Willis was just all snippy and shitty and snitty to everybody. And she stormed into the courtroom. And if you guys don't remember, it was insane. You know, she showed up in the middle of the hearing and, you know, just strutted right on in there. And it was just absolutely ridiculous. It was absolutely ridiculous there. If you guys haven't seen it before, she got all snitty about it. And
Willis, how did you know to come into the courtroom right then?
There were people I was pacing in my office.
Okay.
And I heard someone yell, "His testimony is done." It only made sense to me that I would be your next witness. And I've been very anxious to have this conversation with you today. So I ran to the courtroom.
So as soon as you heard that Mr. Wade was done testifying.
And she did run the courtroom. You could see she's huffing and puffing. She came running down there. She wanted to fight.
And that's when you just assumed you would be the next witness?
It only makes sense.
Did you listen to any of the testimony?
I've been in my office pacing, ma'am.
Did you listen to any of the arguments?
I did hear the arguments this morning. It's ridiculous to me that you lied on Monday, and yet here we still are. And I did listen to that argument.
All right, so that was it, just the argument, no testimony.
Right, I listened to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday. And I'm actually surprised that the hearing continued, but since it did, here I am.
Great. So let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade and talk to him about the motion that I filed to disqualify you?
100% they fucking did, and we all know they did.
On this first January motion?
Yes.
I don't know.
Look at that motion, chat. That is her just foiling the shit out of all the money and scumbaggery and the shitty things Fani Willis did.
You could say talked about. I probably had some choice words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman. Me, not so much.
Yes, you being the ratchet ass hoe who does hoe activities with hoe tendencies, and hoes are her friends and hoes are her enemies. With hoe energies to do what you do and blue what you blue and screw what you screw. That's Fani. That's Fani. Yes, he was a Southern gentleman. Yes, he really was. And she's like, I'm the ratchet hoe. April Betts says, I would love for Fani Willis to end up in the Fulton County Jail. Oh, only God would. If God has a sense of humor, and he does. So do the Fates. At one point, they might do that to her. So anyway, Fani Willis did all of that. And they did this in front of the judge. And you guys remember this judge. Judge McAfee. So, you guys were able to see Fani just talking shit, right? Okay. Anyways, this is Judge McAfee, and this was the case that was being held in front of him. And this went on forever, this stuff here. And I just want to show you guys, for example, on, all of us, a lot, like everybody in the country was covering this. But there was just so much, so much going on. And these cases just kept going and going and going and going. It truly was an impressive thing that this kept happening. And you know, when you talk about it, well, actually, hold on here. When you talk about what happened here, it's very like this was a never-ending saga. And then it ended up with Fani Willis and the Georgia Senate trying to subpoena documents from her. And she was being held in contempt in other cases. And she was refusing to comply with subpoenas, being held in contempt. I mean, guys, this is just like my channel. You know, look at, I mean, this thing went on and on and on. Like, this went on for a while. This was an entire, you know, Ashley Merkin went to the Georgia Senate to testify. You know, there was just, it keeps going and going and going. You know, there was an entire saga to this. And I think you guys, you know, yeah. This went on forever. And we finally get to Judge McAfee, and he releases his opinion saying, you know, we get to the end and we get to this odor of mendacity. The odor of mendacity, 100% correct, Alyssa. The odor of mendacity, that something doesn't add up. So this went up to the Court of Appeals, and the Georgia Court of Appeals removed Fani. Removed her from the case. And they said that her office had disqualified themselves. They said she had disqualified herself because of their actions. So for Fani, after the Georgia Court of Appeals, she didn't like that. So she appealed it to the Georgia Supreme Court. And she sought a writ of certiorari. Because the way it works is, if it's not a case of exclusive jurisdiction, you have to ask. You have to ask. The court to take your case. And Fani did that. And yes, Brandon, the anime guy, is correct. Yes. And at the end of the day, McAfee was too weak to do it himself. Fulton County is the most corrupt in Georgia. I agree, but we saw from all those judges. You know, the YSL case and this case, they're all pussies. So, exclusive, some of them, they have exclusive jurisdiction and original jurisdiction. You know, either or, depending on how they wish to phrase it. So Fani went to the Georgia Supreme Court to get her case heard. And today, the court released their thing. And here's what happened. Air Dudu says, what an embarrassing profession. Well, and down there it is. Say, the beard is looking mighty epic. Yeah, thank you. I try. It's a confederacy of dunces. Down there, yes, it is. Like I said, in the YSL trial, they need to bulldoze that courthouse and make a parking lot. Brandon says, wait, the court released more today? Yeah, the Supreme Court of Georgia released its opinion. So here we go. Chat. We are going to zoom in on this and get this rolling. Like Josh Brolin. So you can see it's the Supreme Court of Georgia with multiple cases. Because remember, each one of these cases is a criminal party. Each one of these cases is a party. And remember, not every party was involved in this. So of the 15 people left, not everybody's here, but it affects them all. This came out today, early in the morning. And it said the Honorable Supreme Court met pursuant to adjournment, and the following orders passed. In the case of Michael Roman, I believe that's who Ashley Merkin represents, was Michael Roman. But you have David Schaefer, Robert Shealy, Mark Meadows, Donald Trump, who is represented by Steve Sadow, who is apparently, I watched that guy. That dude's a fucking pit bull. Kathleen Latham, Rudy Giuliani, Jeffrey Clark, and Harrison Floyd. And it says that today the Supreme Court has denied the petition for certiorari in these cases. Bam! There you go, chat. All right, you guys have a great night. Remember, chat, I will see you tomorrow. Remember, till next time, just because you did doesn't mean guilty. Yada, 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 blah, 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 blah. Good night, chat. No, we're going to do a little more than that. Suffer, Fani. Suffer. Total Fani death. TFD, chat. TFD. And you know what that means also? TTV. Total Trump victory. Dominating. Godlike. Erica said, oh my God, I was about to cry. Oh. He got me. I mean, it's a DSP level joke right there. That's fucking fighting words, sir. Yes, but just dominating. It's not funny when the casino does that joke. It's not funny now. Well, yes. Dominating, more like Donaldating. Yes. Yes. Monster kill. So, yes. Let's get some subs to continue the stream. All right. Let's keep going here. So these are all the appeals cases it came from. And, it's the Supreme Court of the state of Georgia and hot Atlanta. The hottest Atlantas. So, okay, so what do we have here? So this is a justice concurring in the denial of certiorari. And he says, I agree with the court's decision to deny these petitions for certiorari. Here's why. Do you really need to add here's why? That's very stream of conscious writing. That's stream of consciousness writing, and that's not befitting for a court like this. It says this court's power to review cases the Court of Appeals has already reviewed. What we call review by certiorari is set by our state constitution. It grants the authority to review by certiorari only in cases the Court of Appeals which are of a gravity or great public importance. This means we generally do not grant certiorari to review just because the Court of Appeals or the trial court may have got something wrong. And you know what? Isn't that kind of disheartening? When you think about it? No matter what you could be 100% right. The courts could have fucked you at the trial court level. The appeals courts could have been 100% wrong. And you know what the Supreme Court's going to say? Nah, well, you're going to have to suffer. Have fun in prison for the rest of your life. Think about that. Just because it's wrong doesn't mean they'll fix it. That is for mere error correction, which I love how Chad, I told you before, courts only exist to support other courts. If they did their jobs, they would collapse the systems upon which they operate. That's that, so they cite some cases here. They say, nor do we typically grant review just because a case or a subject matter happens to have found its way in the public spotlight. Instead, our focus in assessing whether a case warrants the exercise of our certiorari is supposed to be its potential impact on the law of Georgia. To gauge that impact, we ask whether the case presents a legal question of gravity or great importance to the public. And they put out certiorari is not a right. That's correct. That says we typically assess whether a legal question has given sufficient gravity by asking, for example, whether the Court of Appeals has decided the question in the way that conflicts with other decisions of the Court of Appeals or this court. Did they answer a legal question by applying precedent in this court that should be reconsidered? Or they decided an important question that is likely to reoccur and has not been, but should be settled by this court. And they say these are not exclusive, meaning there's other ones, but they reflect the main aim of certiorari, ensuring our court's interpretation is correct, settled, and ultimately uniform with respect to important legal issues the courts and litigants are likely to see in the future. Well, guess what we're not going to see in the future? A bunch of corrupt motherfuckers like that. I mean, whoop, uh-oh. And they say, but identifying a question of sufficient gravity is not on its own enough to warrant review. That question must be presented by the case when it arrives at the court. And although we entrust the court to trust it with the responsibility to settle the questions, We are still a court, and courts are not vehicles for engaging in academic debates or deciding purely theoretical questions. Yeah, courts can't exist for that. They can't give advisory opinions. It doesn't work that way. It doesn't work that way. And Sweet is saying, what is certiorari? Well, it's like a writ of certiorari. And that's just like habeas corpus. That's what it works there. But certiorari means to be informed. And by being informed, the court's like saying, yes, we're going to let you inform us. It's a writ of certiorari. Your writ that you wish to inform the court has been granted. And the court's going to allow you to inform it of your issue. I know I'm kind of butchering Latin with that, but that's basically what certiorari is. It's the permission to have your case heard. Feasing says, can someone explain this in English? Is the case dead now? Mostly. It's not all the way dead. It's not all the way dead yet. So we'll get to this. So, yes. It's Latin for another beer. So they say, instead we say the law is only as needed to resolve an actual controversy. This says, thus, even if there's identified a question of gravity, we must ask whether that gravity is necessary in some way to resolving the case. If not, for example, answering that question wouldn't matter. Or if that question was not even squarely presented or decided, meaning if the court didn't properly do it, then reaching out to decide that question anyway would exceed our limited role. In other words, and God, they have a very limited way they can grant hearing. I mean, in Ohio, it's very much like the Supreme Court. Like, are there, circuits and districts in confliction, things like that? But in Georgia, you have a court of appeals. It's a unified court of appeals. In Ohio, in many states, you have districts, like regional courts of appeal. In Ohio, there's like 12 of them. But in Georgia, you just have the court of appeals. Same way in Minnesota, it's one court of appeals. But they say before granting certiorari review, we must ensure not only that identifies a question of gravity, but the question is actually presented by the case, and answering it would be helpful. So they have three things they have to meet. Is there gravity? Is it actually presented? And then finally, will it actually help if we do anything about it? So there's three things they have to do. And they say here the state asks us to grant review to answer whether a prosecutor may be disqualified based solely on an appearance of impropriety absent a finding of an actual conflict of interest or forensic misconduct. They say in an appropriate case that might warrant our review. Oh, oof. And they say the legal basis They say that might warrant our review. They say the legal basis for a rule that prosecutors may be subject to disqualification based only on the conduct that creates an appearance of impropriety is not clear. He said, I'm not aware of a specific constitutional or statutory basis for this rule. The court only suggested that basis for disqualification as a possibility, arguably in dicta, meaning just in the kind of the musings, but the non-holding part of a case, for attorneys generally. In a 1981 case, Blumenfeld, parenthesis, notice, chat, Feld. And that decision relied on a since scuttled rule of professional responsibility addressing the rule of impropriety. So this case is based on a rule that doesn't exist anymore. And it says the lawyer should avoid even the appearance of impropriety, which I think is a good idea. That should be a rule. On the other hand, the idea that public prosecutors should be held to a higher standard than private attorneys for the purpose of disqualification is not without force. And it finds some support in the language of our earlier decisions. And they say the administration of the law should be free from all temptation and suspicion. And that a prosecutor should not later appear as counsel for someone he prosecuted. Yeah. And they say we have not the slightest idea that anything intentionally wrong on his part was intended. But they say for a lawyer to defend the perpetrator of a battery in a civil case when the lawyer prosecuted them criminally. Yeah, it doesn't work. That's the appearance of impropriety. And they say if this question whether conduct creating the appearance of impropriety is alone as grounds for disqualifying a prosecutor is presented by future cases, we may well need to take it up on one of them. But in my view, that question is not presented by this case, at least not as it appears before this court. And they say the root of the problem is the state's approach to litigating this issue on appeal. You fucked up, Fani! Safa! Oh no, Fani bros! This bitch was so conceited, she was so smart, and she could do whatever fuck she wants. Strong black woman. And they fucked it all up. Oh no. Oh fuck. Shit. So, oopsie poopsies. Yeah, whoops a doodle. Yes. Black. So smart she puts her dress on backwards. Well, if it's on fire, you need to get out of it. That's a smart way to do it. So, in the Court of Appeals, the defendants here appealed the trial court's disqualification order, which found that the conduct in special prosecutor created a significant appearance of impropriety, and two, as a remedy, determined that one of two of those prosecutors would have to withdraw from the case, meaning Fani or Nathan Wade had to go, and that's what McAfee determined. One of them had to go, but the office itself could still prosecute it. They say in doing so, the defendants, So the trial court also concluded that certain of the district attorney's public comments were legally improper under a section of the order titled Forensic Misconduct, but the court went on to deny the motions for disqualification and dismissal. And that's true. So in doing so, the defendants did not contest the appearance of impropriety finding, but they contended the trial court's version of one of you has to go was error, and that it should have instead simply disqualified the entire, should have disqualified the district attorney and the office. And critically, the state did not cross appeal the trial court's ruling. Instead, the Court of Appeals explained the state asked the Court of Appeals to affirm the trial court's order in its totality, including the imposition of its alternative remedy. Fani bros. Uh-oh. Yes, and the court's just pointing it out. You're like, no, we agree with everything. Are you sure? And you're like, yes. It says, so taken together, the position of the parties in the Court of Appeals pose a narrow and case-specific question for the Court of Appeals to answer. Taking as an unchallenged given both the trial court's finding of a significant appearance of impropriety and that some kind of disqualification remedy was required to cure the harm, was the trial court's chosen remedy an abuse of discretion? This is the ultimate question. Was this an abuse of discretion? That's all they argued here. Yes, Nathan Wade never had any experience doing anything important. He'd fucked around a lot. This is all that matters, guys. This is the case here. And when it comes to appellate matters, you can generally boil it down to a couple things. And one of them is abuse of discretion. Did Judge McAfee did this guy do the wrong thing when he made this entire order? Was it bullshit or not? And Trump and the team said yes. And Fani was like, nope, it's good. Well, what are we going to do here with that? Uh-oh. So, and indeed, that was how the parties argued this. Importantly, the Court of Appeals legal analysis appears to have stayed within that narrow framing. And it says, while the state's failure to cross appeal may not have bound the court to take this narrow analytical path, they also point out, though, that a ruling becomes material to an enumeration of error urged by the appellant may be considered by the appellate court without the necessity of a cross appeal. They say, but neither court was required to reach beyond the parties' framing. And that's the point. The court can sometimes go beyond a framing issue, but if all you've done is presented X, if the court stays within X, you didn't do a good enough job. Like, the court did what you wanted. It stayed within the defined bounds you put down, Fani. The salt is making me thirsty. In its opinion, the court explained because the state failed to cross appeal, our consideration of the appearance of impropriety is limited to the remedy fashioned by the trial court. And notice this is Roman v. State because he's the top guy on the caption. But, it's limited to the remedy fashioned. And the court went on to say it had to address the remedy in the context of the appearance of impropriety caused by the conduct of a prosecutor. They say, which distinguish this case from private counsel cases. And they say, and the court framed this key holding as one about the choice of remedy. The choice of remedy. Concluding the trial court erred by not disqualifying the district attorney because the remedy crafted by the trial court to prevent the ongoing appearance of impropriety did not fully cure the harm. And that's correct. And no other remedy will suffice to restore confidence in the integrity of the proceedings. So in short, rather than deciding any broader question about whether the appearance of impropriety can serve as an independent ground, the Court of Appeals appears to have resolved a narrow case-specific dispute about the trial court's choice of disqualification. They didn't, basically, Fani filled out the test. She put her name at the top of the test and forgot to do the fucking homework and just turned it in blank. So the court had nothing to go on. And they say, if that's the best reading of the decision, and he says, and I think it is, the decision not to raise a question of gravity that warrants our further review. Whether a trial court abuses discretion for remedy under these specific and unusual circumstances is not a question of Georgia law at all likely to rise in future cases. Yes, because we're not going to have a bunch of corrupt, fucking ratchet-ass bitch Democrats running around like this. Nobody else is going to do shit like this. Another prosecutor isn't going to do this and start fucking their boyfriend and paying him $1 million. Oh, Fani L. Fani L. Nor does the Court of Appeals' fact-bound decision the trial court abuses discretion create any apparent conflict with the decisions of the Court of Appeals because it's a issue of first impression. Bama Law says that's for writing your name. Yes. But they failed to run plays. They forgot to run a play. Actually, it's kind of like The Simpsons when Bart's running for student council and he forgets to go vote. Fani didn't do anything. And they say, thus, even if one believes the Court of Appeals erred, granting review to answer that question would be mere error correction. And this court generally does not exercise that merely to correct errors that do not have some broader impact. So they're like, we don't care about corrupt brokey hoes. They're hoes. Suffer, Fani. Suffer. That's all you do in Fani. Yeah, McAfee was a pussy. But I think McAfee knew that the Court of Appeals would get in the way and help him. That's a dangerous game to make, though. And they say, to be sure, it's plausible to read the decision as holding more broadly that as a general matter, conduct that creates the appearance can be grounds for disqualifying. And it says, at the bottom, the Court of Appeals concluded the district attorney had to be disqualified to address the appearance of impropriety, explaining this is the rare case in which disqualification is mandated. And they say one might argue such a decision rests on a necessary premise that creating an appearance is a sufficient ground, and in turn, treat that premise as a holding, which, you can do that. And the holding of a judicial decision is more than just the results. It includes the reasoning or principles that were necessary. And that's enough to say, yes, this whole thing here, you could do that. You can do that and saying this is the rare case. There's just certain things here that happened. He says, I disagree with that view in light of the posture and the repeated focus on the choice of remedy. And he says, but I acknowledge that drawing the line between holding and dicta is not always easy. And one judge's holding may be another's dicta. And that's true. Because this will happen. You'll argue, oh, it's holding. No, it's dicta. No, it's holding. No, it's dicta. Rabbit season, duck season, rabbit season, duck season, duck season, duck season. Fire. That's what happens here. There is routinely this fights. And you make the fight. Because if you could say it's dicta, it doesn't matter. Dicta doesn't matter. It's irrelevant. The holding is what controls. And he says, even under that alternative reading, however, I'm not persuaded. For one thing, it's not so clear that there is no conceivable legal basis for holding a public prosecutor to a higher standard, at least as a general matter. And I agree, the prosecutor should be held to a higher standard. You know, prosecutors represent the people and have a duty to seek justice. And they say, for another, even assuming the Court of Appeals held as much, that such a public prosecutor-specific holding would not appear to conflict with any decisions of our courts. And perhaps most important, it is not clear that this legal question will reoccur with any frequency. And they say appellate decisions addressing attempts to disqualify prosecutors are few and far between. Yep, they are very, very few. And only a handful of those addressed a claim that a prosecutor must be disqualified, even in part on conduct that created the appearance. It's very hard to get a prosecutor disqualified. So, Joe, you're saying wasn't yelling a fire in a theater in Brandenburg dicta? No, it was in Whitney v. California, 1925 or 6 case, where they talked about shouting fire in a crowded theater. That was overturned. Brandenburg v. Ohio was a bunch of Klansmen down at Cincinnati being filmed by a news crew carrying guns and talking about, you know, race war. So that was 1968. Yes. Mike Dicka. Yes. They say, could this case change that? He says, perhaps. Perhaps. Excellent. He says, but it seems more likely to me the circumstances of this case are unique, and I am not convinced that parties will rely on it for anything broader than the Court of Appeals stated conclusion based on the findings in this case that the trial court chose the wrong remedy. And that's all it's going to be for. It's always going to be for. It's all it's going to be for. Luke says, okay, what, Schenck? If it was Schenck, I don't recall. Is it Schenck? All right, well, there you go. Schenck v. U.S. 1919, where the socialists were out trying to get people not to go step into the draft, which, in hindsight, yes, no more brother wars. No more wars for the foreign people. But yeah. So. But yes, all that was going to happen here, the only people who were going to give a shit about this were the parties involved, and it was just about this issue saying the judge got it right or the judge got it wrong. And they say, and of course, if this prediction turns out to be wrong, we'll have the opportunity to address it later about the appearance of impropriety for public prosecutors. When it's presented in a case without unusual procedural limitations and other circumstances that make this case a poor vehicle for reaching that question. And they say members of the public may very well be interested in the case underlying the petition, but our focus in assessing the grant is on the law of Georgia. And they say the corresponding narrow question before the Court of Appeals and the limited resolution of that question, the decision does not raise the kind of legal question that warrants for the review. And he says, I'm authorized to state that the presiding justice and Justice Bethel join. So guys already, like I'm telling you, there's 3 already here that agreed. So we have 3 for yes. And then there's another one that didn't join in, but he is here. So if you guys want to know how this wasn't like a 9-0 decision or 7-0 decision. So it said all the justices concur, except Ellington, McMillan, and Colvin, who dissent. So the chief judge did not participate, and one of them was disqualified. So there are 9 justices on the Georgia Supreme Court. So it was a 4-3 decision. It's a 4-3 decision. 4-3 decision there, chat. So what the fuck is that participating for? There might have been issues about him participating or impropriety. There were concerns about it. Maybe he was sick. I don't know. I don't know. I just work here, man. You can call him and ask him. You should call and ask. You'd be like, God damn it. Why wasn't the Chief Justice on the bench? You should pick up the phone. It's like, I need to talk to Chief Justice Peterson right now and be like, listen, you fucker, why weren't you working, you son of a bitch? Yes, is there a published dissent? Yep, there is, and we're going to get to that. We're going to get to that right now. Right now. Yes, they were probably fucking Fani too. So do they follow party lines? From what I can tell, from what I understand, yes. Yes. Epic Fanny says, do you still think Nick will win his HRO case? Yes, I still think the odds are in his favor. I mean, I will say Aaron's attorney is a lot better than Nick's. And if I was Milton, I'd get a new fucking lawyer. But at the end of the day, yes, Nick is still likely to win. So, the Chief Justice was out getting the Jimmy John's order. Well, there you go. This justice is saying, I would grant certiorari because the legal issue presented here, whether attorneys can be disqualified based on impropriety alone, affects every single active lawyer in the state of Georgia. And the decisions for this are on point. Our court's precedent warrants reconsideration. So he's going to make the argument here. And he says some background's required to understand the gravity. Really, is it necessary? And it says in 2023, the state, through the Atlanta Judicial Circuit District Attorney, Fani Willis, DA Willis, charged the respondents in remember, guys, a 97-page indictment with RICO violations. And, notice, where the conspiracy to unlawfully change the outcome of the 2020 presidential election. Respondent Roman moved to dismiss the indictment and disqualify Willis, her office, and Special District Assistant District Attorney Nathan Wade from further prosecution based on the alleged appearance of impropriety, asserting they were engaged in a romantic relationship and that Fani Willis had a personal interest in the case because the more Nathan Wade could bill, the more vacations they could go on. The other respondents later filed motions on similar grounds. And after a multi-day hearing, the court found that the respondents failed to meet their burden of proving the Fani acquired an actual conflict of interest in the case through a personal relationship. The other grounds for disqualification, including forensic misconduct, are also denied. However, the established record now highlights the significant appearance of impropriety that infects the current structure of the prosecution team. In addition, the trial court noted that the odor of mendacity remained with respect to the testimony of certain witnesses. Remember, when Fani testified, it was awful. Nathan Wade was just as awful. Guys couldn't remember shit. I don't recall. And they say reasonable questions about whether the DA and her hand-selected boo testified untruthfully about the timing of their relationship further underpinned the finding of an appearance of impropriety and the need to make proportional efforts to cure it. And it says, as the remedy for the financial cloud and potential untruthfulness, the court provided two options. Fani and her office could step aside, or Nathan Wade could withdraw from the team. So the trial court also denied the respondents' motions to dismiss the indictment, and that's true. They say on appeal, the Court of Appeals affirmed in part and reversed in part a divided opinion. Saying relying on a leading case, the majority explained that in Blumenfeld, noticing, the court held that a trial court's disqualification based on the appearance of impropriety due to status was improper, and the appearance of impropriety based on conduct was also generally insufficient to justify disqualification. But this court left open the possibility the appearance of impropriety based on conduct could justify disqualification when the interest of the public at large outweighs the client's interest in choice of counsel. And they say the majority opinion explained the district attorney's role in the administration of justice justified disqualification because there was no countervailing client's interest in the choice of counsel. And that's true because it doesn't work that way. Like the client is the people. And you can't do it there. You can't determine, well, the client wants that attorney. Well, the client is the state of Georgia. And they say, relying on this reasoning, the trial court's finding of the appearance of impropriety, the majority opinion concluded this is the rare case in which disqualification is mandated, and no other remedy will suffice. And they say, by this holding, the Court of Appeals extended Blumenfeld, ruling that the appearance of impropriety alone was not only sufficient, but actually required disqualification under these circumstances. Shouldn't it if the prosecutor's acting with the appearance of impropriety? Isn't it matter? Doesn't it matter there? You guys, what did you guys build? I can't see. What did you guys didn't build? Oh, you guys built, but it's not right. There's too many I's, there's too many G's, there's one E and there's two R's. Like, you guys get good. Get good, chat. I'm like your dad. I'm not going to notice until you do it right. I'm not going to notice till you do it right. Kathy, your realtor living in New Jersey. Remember, guys, but not Jersey, the island of Jersey. Says, what happened to Harrison Floyd? He was in jail for months. He got released. He got out of jail, and yeah, I don't know where he's at now, but yeah, the guy got out of jail, and yeah, the guy spent a lot of time behind bars. It's kind of funny. They gave Trump and all these other people breaks, but the black guy on the team, they all fucked over. Like, you know, there was a black guy and a black chick, and it's like they fucked over, you know, Harrison Floyd so badly. Very funny. Very funny. You know, how that works down there in the South. But thank you, Kathy. Spud gun for £2 sterling. The King Sterling. Says, that was mean. Keep it up, fat man. Well, thank you. Thank you. So, all right, let's keep going here, chat. They say on certiorari, the parties focus their arguments on whether the Court of Appeals erred in the remedy that it ordered based on the appearance of impropriety, assuming, as did the lower courts, that in other case law, that the appearance of impropriety in the context of attorney disqualification remains good law. I question that assumption, which is the linchpin in the Court of Appeals decision, and therefore part of its holding. And she's challenging the holding. Now she's saying it's not dicta, it's the holding. And she says that the court relied on Canon 9 of the then existing Code of Professional Responsibility, which says a lawyer should avoid the appearance, even the appearance of professional impropriety. But that was removed. In January 2002, they removed Canon 9. Where's J-Rock? We need a Georgia attorney here. So. Guys, do a Clyde Tower. You guys can do those, right? And they say, so any mention of the appearance of impropriety didn't exist anymore. And they say, see rule professional conduct, 3.5. They say, indeed, the United States Court of Appeals for the 11th Circuit, which is where Georgia is, but it's called the appearance of impropriety standard, no longer recognized by the State Bar of Georgia and its rules, and outdated, opining that a district court properly chose not to apply it. And they say the model code has been replaced by the model rules and thus does not govern the professional conduct of attorneys in the Southern District of Georgia. And they say under the model rules, the appearance of impropriety is not a ground for disqualifying a lawyer. And they say no other cases from our Court of Appeals have recognized this change in the rules or considered how it affects anything and whether an attorney may be disqualified solely based on the appearance of impropriety. So they're pointing out they haven't had a chance to deal with this since the laws were changed or the rules were changed. And they say the Court of Appeals case law complicates the issue because it appears to have repeatedly read Blumenfeld to require an actual appearance of actual impropriety or conflict of interest to accompany the appearance of impropriety. Though that rule, whether right or wrong, has never actually been announced in our cases. So what they're saying here is that the Court of Appeals made up its own case law. And we talked about this with the reverse discrimination, where if you were proving you were discriminated against as a white person, you had to do extra steps. You had extra things you had to do. Instead of just claiming discrimination, you had to do discrimination plus. Well, they're saying that the Court of Appeals made their own case law, and that's not proper. Oh my God, chat, you're trying so hard. Oh my God. It's like a hooked on phonics convention over there in chat. So they say, although the dissenting opinion in a couple of cases here, for the proposition a conflict or actual impropriety is required, they talk about the majority in the Roman case inexplicably did not cite or address any of these cases, even though they're binding. And they say the Court of Appeals was obligated to continue to rely on the older precedent until such time as the older law was properly overruled. And they say the issues about whether something remains good law and the appearance of impropriety alone can support the disqualification is a question of gravity. It is, sure, but how much gravity? And they talk about, well, a petition for the writ of certiorari, and these are the court rules, will only be granted for cases of great concern, gravity, or importance. So, they talk about a case from the Court of Appeals on an important matter. It's in conflict with other decisions. From the Court of Appeals on an important matter that faithfully applies a decision of this court, but is requiring reconsideration. The Court of Appeals cases that decided an important question of state law that is likely to reoccur, and it has not been, but should be settled. Well, that's not happening ever again. Are they faithful applying something? No, you can't force them. And then is it in conflict with other decisions? No. So none of these apply. And it says, these petitions meet the definitions of gravity. To begin with, the issue of the appearance of impropriety alone can justify disqualification. Affects every single lawyer. Only the scumbag ones. And this qualifies as an important matter. And they say the Court of Appeals decisions on this issue are in conflict. Well, and they go on here and they say, finally, the issue of whether the appearance of impropriety can justify it is important. Question of state law is likely to reoccur. How is it likely to reoccur? How is it likely to reoccur? It doesn't. They don't say that. And they say most states like Georgia have patterned their lawyer ethics rules on the model rules of professional conduct. We have as well in Ohio, including its deletion of the appearance of impropriety. And they say many of those states have subsequently rejected the standard and do not apply it. And they cite all the cases they're looking here: New Jersey, Nebraska, Oklahoma, Southern District of Alabama, Kansas, Illinois, a lot of states, South Carolina, Court of Appeals, all kinds of places, Chad, all kinds of places. Then it says most states, however, continue to apply the standard as a factor that may be considered in deciding disqualification, but is alone insufficient. They cite other cases: Maryland, Wisconsin, North Carolina, Vermont, Rhode Island, Iowa, Illinois, 2004, Ohio. And I have seen this, Kala versus Aluminum Smelting and Refining Company. I have seen this case before cited. Connecticut. And they say other states have concluded the appearance can be sufficient by itself. So they talk about, places where it's okay now. And there's only, well, what cases can you do that in? The appearance of impropriety is sufficient. Okay, well, what cases? West Virginia, Idaho, Louisiana Court of Appeals, Arkansas in 2006, Tennessee, Southern District of West Virginia. They're re-dipping back into the well there. South Dakota, Colorado appellate courts, Kentucky, Alaska, Michigan appellate courts, Maine Supreme Court, Pennsylvania Supreme Court, Arizona Supreme Court. So there's a lot of places that it works. But you can see there's major splits in the United States. Major splits. And they say, and even this rough grouping of case law remains questionable. They say with the state of the law and the issue being confusing and even inconsistent, much like the state law of our own. And I note that several states treat the issue differently depending on whether it is in a criminal or civil context. And that's important. They're going to be differently and treating the issue differently. Is it criminal or civil? And this survey of other states demonstrates that it is an important one that is likely to reoccur. Really, you're going to, yes, you might have to disqualify another prosecutor for the appearance of impropriety, but the way this all shook out, no. No, this will not happen again like that. This will not happen again. And they say to add even more gravity, this is an issue that's likely to reoccur. And they point out that then in the event that the prosecutor in a felony or misdemeanor case is disqualified due to improper conduct, that such case is dismissed by the court or a subsequent prosecutor tackling the case following such any disqualification. Any defendant against whom the charges are dismissed shall be entitled to an award of all reasonable attorney's fees and costs incurred by the defendant in defending the case. Based! Isn't that? That's actually pretty cool, isn't it? Isn't that pretty cool? Like, Georgia did something pretty base there. Like, the attorneys, you get this case tossed, you can get some money on it. So, it's a way to make some money there. And they say, as such, there's now a financial incentive to move to disqualify prosecutors. Oh, fuck off. Fuck off. Fuck you. You are fucking bullshit lying. Fuck off. That is such bullshit from a... Well, the prosecutors or the defense attorneys have an incentive. No, their incentive is to get their client off because then they can get more business. But yeah, this is also a great point. Another. And... Okay. Yes. And... So the fuck what? So the fuck what? Do you think Sean will show an order if we get a super chat tower? I mean, sure, but you guys don't do a super chat tower. That's cheating. That's cheating. And it says, this shows that although the primary concern centered on the partisan politics surrounding the bill, underlie the cases of certiorari on review here. One of the concerns is the law would be abused in future cases, having a chilling effect on criminal prosecutions. Oh, well. Oh, well. Who cares? That means less people get prosecuted. That means less people get stuck in the Fulton County Jail. That means less people have to deal with Fani, Willis, and her corrupt ass. What's not to love? Well, there's already enough people facing charges out there. I mean, remember we talked about that case down in Georgia where the guy sat in jail for 10 years for a murder charge for his trial. So, yes, one of the ways to disincentivize that is not having a prosecutor behaving properly. I agree. Imagine that if the prosecutor doesn't act like a fucking shitbag, nobody will have the ability to do this. It's so easy. It's so easy. Yeah, it means less people die of scabies in the Fulton County Jail. Guys, we went over that. We went over that report. In the Fulton County Jail, these guys are tunneling through the walls to attack each other. Like you're in a part of the jail and there's a brick wall and concrete blocks between you. Dudes are cutting through that to go fight and kill people. So, just garbage, man. It's absolute garbage. And it says the opinion adds to that incentive to assert the appearance of impropriety, because that standard is amorphous and likely easiest to meet. Yeah, well, suffer, judge, suffer. So they say the Law of Lawyering, which is a book, it's an actual thing out there, guys, that does these massive surveys of the law. In describing the appearance of impropriety standard as nebulous and rejected by most courts is the sole basis of qualification. Yeah, okay. And they say that we acknowledge disqualifying counsel may impose hardship on litigants, and we share the concern that the tactical use of disqualification motions to harass opposing counsel. Well, the litigants, who's it going to impose hardship on? The prosecutors have infinite money and time. Who the fuck are you people? This judge has got some nuts. And this is a Richardson Merrill versus Kohler Supreme Court case. And guess who it is? Justice Brennan. And he says the tactical use of disqualification motions is a deeply disturbing phenomenon in modern civil litigation. Notice, it's a civil case, and guess where we're not at, Judge? Civil land. But yes, no doubt these cases are unusual, and these cases are usual, and the cases are politically charged due to the subject matter and the parties involved, including the President of the United States. But neither the unusual underlying facts nor the identities of parties deprive the case of gravity. And this is because the legal principles underlying the Court of Appeals ruling, including the proposition of the appearance alone, are not bound to a specific factual scenario or these parties, but will apply to a wide variety of situations which a litigant could show only the appearance of impropriety. And those situations are likely to reoccur with some frequency. Well, it sounds like you should fix your fucking problems. And they're saying I would have granted certiorari no matter who the parties were or the underlying facts. Bullshit. Bullshit you would have. Bullshit you would have. If this is just some poor black guy in jail, you wouldn't have done that. Bullshit. 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 Absolute bullshit. I mean, nobody buys that. Nobody buys that. No one buys that. Nobody buys that. So, and also real quick, some of you guys are wondering about the political makeup of I'm preaching social justice. I'm just acknowledging the truth. This judge wouldn't have given a shit. If you guys are wondering, according to Ballotpedia, in the Georgia Supreme Court, everybody's nonpartisan, and they've all been appointed, except for one of them. They were all fucking appointed by Republican governors. Brian Kemp, Nathan Deal. I don't remember the fuck Nathan Deal was, but whatever. Never heard of this guy. But anyways, Brian Kemp elected appointed a shitload of them. So there you go. Yeah, then there's no rush in deciding it now. If it'll just wait a month and you'll get a new appeal. Exactly. Just give it a year. I mean, how many times it's happened before you denied it? Because this happens all the time. I mean, yeah, but their argument is the new law passing has kind of ruined this issue and has made it a new problem. So, in short, this requires a resolution of a novel issue of gravity about which the state of the law is confused and conflicted, both in Georgia and across the country, and thus warrants consideration or reconsideration by the court. Moreover, this affects the bench and bar across the board and will likely reoccur, such that guidance from the court is desirable. Well, once again, this sounds like an advisory opinion at that point. You're not allowed to do those. No advisory opinions. Therefore, I would grant certiorari to resolve the issues based on the impropriety and propose the following questions. And this is the argument they wish to do. The proper questions. So to the extent Georgia appellate case law permits disqualification on the basis, does that remain good law following the adaptation of the 2001 rules? That is a good question to ask. And it says, if not, what is the legal basis for disqualification solely on the basis of the appearance of impropriety? Another good question. And 3, did the Superior Court abuse its discretion by denying the motion to disqualify, even though the court found a significant appearance of impropriety? And they saying, I'm authorized to state that Justice Ellington and Colvin join in this dissent. Signed by them. So, so what's happening here? So what does this mean at this point? Well, it's not over yet. There's still some stuff that has to happen. And Phil Holloway, if you guys don't know who he is, Phil Holloway here, he is he is on a couple different things here. Does all kinds of stuff. He's really killing it out there. Shows up on like Megyn Kelly and all kinds of great stuff. Actually, very nice guy when he talked to him. Super, very nice. Super nice behind the scenes. And he just points out, like, yeah, this is well, there you go. In Bentonville, Arkansas, look at these whores destroying the Charlie Kirk Memorial. Yeah, too bad. Too bad they can't light on fire. Too bad they can't light on fire. So, but yeah, anyway, this is sorry, I was gonna bring him because he kind of breaks down what happens here. So what happens from here? Well, he kind of explains what this means for the indictment. The indictment is still pending, but there's no prosecutor for the case. And it says in Georgia, a small state agency, the prosecuting attorney's counsel will decide whether to assign the case to a different DA, prosecute itself, or dismiss it. And they're not going to do this one. If they do A, that prosecutor is very likely going to end up being it's going to be a smaller prosecutor who's immediately going to go to here. The way it's been explained to me, that's an outcome. But the more likely outcome is they're just going to go straight to dismissal. So they'll get their way. It'll be done, but it's not dead yet. It's on life support. And he says, what will the prosecuting attorney's counsel of Georgia do? Certainly dismiss. And they say no other Georgia prosecutor wants the case because they would essentially have to start over to clean up the mess left by Fani. And, he does finish with a little bit more here. And he says, it's no other DA has her budget. And that's the big thing here. You need $1 million budget, nor her appetite for lawfare. They're going to dismiss the indictment. So there you go. Dimitri Bell says, don't you think you get found not guilty? You prove the guilt. The innocence is assumed. Hold on. What do you mean? Are you saying, don't you think, are you trying to say that if you get found not guilty, she should be presumed innocent? I'm not sure. Hold on. I'm not. Yeah. I'm not sure. I'm a little confused there. So, will it be dismissal of prejudice? It's just going to be dismissed and it's done. It's not going to be allowed to come back. But yeah, it'll be a dismissal of prejudice. It's Dunsky. Done. Dunstan checks in. Dunsky checks in. And then Bass Player 2011 says, I don't know what's more embarrassing, this or Tiffany Henyard. This is pretty bad. Because honestly, you guys, of these cases that Trump was facing, this was probably the stronger one. Because Trump's big issue was he had signed a bunch of documents and he knew their argument was he knew they were bullshit. They probably could have got him on that. This was probably the strongest case involving directly the election. Now, you could say that the shit in Alvin Bragg in Manhattan was, but this was directly about the 2020 election. And this was probably the strongest case they had. And Fani just wouldn't fucking let it go. Fani just wouldn't let it fucking go. And she wouldn't let it go. And I mean, what happens at that point? What happens at that point? Like, I don't know what you do. I don't know how you handle this. I don't know how you do it. So, but she just couldn't let it go. She came. You guys remember we watched that, and I'm going to try to bring this up, see if I can find it real quick. If I can find it on my channel here. But remember, Fani came strutting her shit into that courtroom like her hair was on fire. And she was all about acting like that ratchet ass hoe when she came in there. And it was interesting. I mean, remember this woman, this whole thing about Fani is, and here you go. Like, if you guys don't remember, we're gonna go back to private level.
Why didn't you tell on the disclosure form so that people will know the nature of the relationship between prohibitive sources and the public official, in this case, the district attorney, who happens to then make a decision to hire someone that ends up being paid hundreds of thousands of dollars, or his firm and him, and none of that is revealed. And the answer is, oh, it's unrebutted. He's explained it's all in cash. Let her get up and let's, and obviously, we are advocates in our position, but that explanation of cash does not pass the smell test or the straight face test. She needs to go on the record. She filed this motion with his declaration. We've seen what happened here. Now, I'll just 2 or 3 more sentences. We need to have the full.
Chad, I'm going to find that spot where Fani shows up here. Yeah, so see, Fani came storming in the courtroom, and here we go.
Serious business for a lawyer or anybody. And then suddenly he's changing. She files her financial declarations, same problem. We need her in here to go over all.
And look, she came in there and threw her shit on the desk, and here she is, ratchet-ass woman herself. So, yeah, her weave, like her weave was on fire, yes. My mic is cutting in, and I know that's why I stopped it, so we could talk. But anyways, yeah, here we go, guys. Oh, you're going to hear her do that thing. Here we go.
This and to explain exactly what happened. We would ask the court that the court allow Ms. Willis to be called and interrogated on these matters.
And I would, to Your Honor.
Just a moment, Ms. Willis. So, Ms. Cross, I don't know if you want to speak with Ms. Willis now. It's sounding like maybe they're withdrawing the objection to the motion.
I believe the motion to.
Or does Ms. Willis want to take the lead here?
We'll draw the motion to quash Ms. Willis.
Based on the. I'm ready to go.
Okay, so
And the reason was she was subpoenaed, and Fani Willis was fighting it initially. But she couldn't let it go. And this is the problem, chat. This is why attorneys tell you don't get fucking wrapped up in your shit, because you lack the clarity. Fani Willis couldn't do this. She lacked the clarity to not go in there and step all over her dick. And she did. And look where this led her. Her showing up fucked herself. Is there closed captioning? Yes. Here we go.
the position of the district attorney at this point is that she's no longer contesting the subpoena. Ms. Merchant has called her as the next witness.
I would ask, I need 3 documents in front of me, and they're the 3 filings of Ms. Merchant.
3 filings.
Notice that witness, I need this. It's like, fuck you. You get it when you get it. Look at her. She's so fucking mad. And guys, I've told you this. When you get up there, you're in a fucking ambush. You're like, she voluntarily, remember, I think I even said this at the time. She just voluntarily knows you can see there's a sign standing there saying, you're going to get schwacked when you go up there. And that's what the witness stand is. It's a place for you to get shot at. You're going to sit there and people are going to take pot shots at you. And you don't know what the fuck's going to happen necessarily. And she knew it. And it said, you're going to get fucking ambushed if you walk up there. And she's like, fuck it, I'll go up there. You never go up there. It's a death trap. You never want to go up there. You never want to go up there. Debbie says, I will reiterate, proper foundation garments are a must, ladies. Yes. Well, yeah. Weren't there like 10 lawyers she had to go against too? Yeah, including, like Ashley Merkett, Steve Sadow. Like, all those guys are friends with Brian Steele. They're all like Brian Steele was too busy with the YSL trial, but these are like the heaviest hitters in the state of Georgia coming in to fight. Yeah, she was convinced of her superiority and she fucked herself. This is hubris and anger clouding her judgment, and she fucking ruined herself.
Does anyone have the 3 filings of Ms. Merchant? Does the court have the 3 filings of Ms. Merchant?
When you say the filings, you mean like the pleadings?
The pleadings, yes, Your Honor.
Okay. I think we could locate those for you in the supplemental.
I want the one filed on January the 8th, the one filed immediately after we filed ours, and the final one.
And listen to her voice is cracking and it's quivering. Does she sound like she, do you feel in control? Do you feel in control right now, Fani? Do you feel in control right now? No, this is not. She's convinced of her superiority. You don't seem to understand her. Oh, I understand her mindset. I 100% understand her mindset. She's getting high off her own supply. She's believing her own bullshit. She thinks it's the smartest guy in the room. Yes, that hairline is rough. Yes, and does that make you feel powerful? So, my voice breaks when I'm angry. Yeah, but she is not in control right now. Yes, she's balding. The wig glue is running down her forehead into her eyes. Oh my God, it does look like that. Say roof. Roof. So,
If you want to take a break to get them, I can make a copy. I think we have one.
The only copy I have is going to have my notes on it. So if we don't have a clean copy,
We have a 5-minute break during.
Let's
I'll get
take-
the documents.
Victory hasn't defeated her, though. Victory has not defeated her, Dimitri. So,
all right.
I'll sit here and wait for him.
I don't know what it is.
so we'll skip ahead here. I forget how long it takes here. Here we go. And there she is with her
Do you swear me,
fucking,
Your Honor?
and she's got her fucking crumpled up paper. I mean, think about this, guys. We've watched, and I think we talked about this at the time, but now, even now, a year later, because what day was this? 1 year ago. February 15th, a year and a half ago. Think about, where is all the time gone? Where's all the time gone? And she comes strutting in with her fucking ratty and tattered paper that she's got in her hand. She looks like every pro se nutbag litigant. Every pro se nutbag litigant. She is the biggest caricature of this all. So, hard to think this is all old now. Yeah, I know.
Whomever would like to.
We got Deputy Scott usually. So let's go wait a minute, let everyone get situated, and then we'll go back on the record. If you could swear in our next witness.
I would, and I do apologize. Hannah. Do me a favor. Yes, sir. District Attorney Fani, Fani.
Yeah, spell your name for the record. District Attorney. No, your name's Fani Willis.
Last name is Willis.
Ms. Willis, how did you know to come into the courtroom right then?
There were people, I was pacing in my office,
Okay.
and I heard someone yell, "His testimony is done." It only made sense to me that I would be your next witness. And I've been very anxious to have this conversation with you today. So I ran to the courtroom.
So as soon as you heard that Mr. Wade was done testifying, that's when you just assumed you would be the next witness?
It only makes sense.
Did you listen to any of the testimony?
I've been in my office pacing, ma'am.
Did you listen to any of the arguments?
Why are you nervous? What are you nervous about? Shouldn't you had this in the bag?
I did hear the arguments this morning.
Yes, we learned her dad, because he testified at some point, is a Cornell West knockoff, a fucking loser commie also. Yes, she is the epitome of arrogance. It's hubris. It's hubris, and she paid the price.
It's ridiculous to me that you lied on Monday, and yet here we still are. And I did listen to that argument.
All right, so that was it, just the argument, no testimony.
Right, I listened to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday. And I'm actually surprised that the hearing continued, but since it did, here I am.
Great. So let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade and talk to him about the motion that I filed to disqualify you?
On this first January motion?
Yes.
I don't know if you could say talked about. I probably had some choice words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman. Me, not so much.
Okay, but my question was, did you have a conversation with
I didn't
him?
have a substantive conversation.
You did not.
I read this motion, skimmed it more so, and I've probably said some choice things to him about some of the lies they were told.
Okay.
And then printed in the media because, we used to be in a day and time where you had 60 Minutes and people did stories and they verified information.
You are a fucking liar and a whore and a thief. Fuck you. And now that we know she's a piece of shit, she should be indicted, but she's not.
And you had this great reporting, but it seems today that a lawyer writes a lie and then it's printed for all of the world to see.
Well, I just want to make sure that you answer the question I asked, though. So my question was,
Overruled, Mr. Abadi.
I told you what happened. I read the motion. I am sure I told him what my opinion of it is.
Okay.
And past that, we had no substantive conversation.
you did not.
Bullshit.
Is there something you didn't understand?
No, I just wanted to make sure that
Okay.
you did not have a meeting with him.
Fucking ratchet ass hoe. Is there something you didn't understand? No. I'm fucking dark side fit like fucking this fucking low cash shit. Fucking ratchet asshole. Marky Mark, we're going back through this just to show what she fucking did. Like, look how this went. Look how this went. So.
In the conference room to discuss the
All
motion.
right, next question,
No.
Ms. Merchant.
So in the conference room of my office,
Notice he was trying to say next question, and she just fucking keeps going, so she's answering the question anyway. What's she chewing on? I don't know, crack rock?
within this week, you produced some financial document. That financial document was given to me, something, and I'm not even sure who's given it to him by me or Mr. Abadi gave it to me. And I think he showed me a document in our conference room. But as far as a substantive conversation, I don't believe I've had any conversation with him that is substantive related to this.
Okay.
I have had conversations with him since you filed the motion, but they wouldn't be substantive to this. He sent me very nice sermons that have been done. And so we've had conversations about, did you listen to that sermon? You know, things of that nature. And I would say they were in relationship to this because I think he did it to be kind.
I'm sure. You're praising Jesus when he's slinging that dick. But anyways, that's where we are, chat. That's where we are. Fani Willis committed perjury. She committed perjury. Nathan Wade committed perjury. But in response to all of that, there was something funny that came out today. And it was the attorney for Rudy Giuliani. And this is from Luke. Luke sent this to me, and this is fucking hilarious. So this is going to be Rudy Giuliani's attorney hanging out outside dealing with the Harvey Weinstein case, but also some stuff about Luigi Mangione. But this is Rudy Giuliani's attorney that he's got. And here you go.
A totally different topic regarding Rudolph Giuliani. Those of you who don't know, the Supreme Court of Georgia has refused to hear Fani Willis's appeal about whether her office needs to be thrown off the Georgia case. So therefore, it stays that Fani Willis's office is off the Georgia case. This is the case where Rudy Giuliani is now the primary defendant in the case. It now gets sent to find another district attorney's office, a whole different office in a whole other jurisdiction in Georgia to decide whether they're even going to prosecute the case. So from the greatest mayor in the city of New York having to go down there and face these charges, we're hopeful that this chapter is closed for Mayor Giuliani, who just 1 week ago down here at September 11th was hailed once again as the hero of the city of New York. So that decision came down this morning from the Supreme Court of Georgia. John Esposito, my partner, worked diligently on it, and we're very, very pleased that the Supreme Court of Georgia has made the decision that there was a conflict of interest when District Attorney Willis assigned her boyfriend to be the special prosecutor, whereby he gained a significant amount of money. So that county is off the case. They have to find a new county prosecutor to take over the case and decide whether they're even to go forward. And we're cautiously optimistic that they will decide not to go forward, and Rudy Giuliani will have this behind him, as will President Trump, who he was the lead named defendant. If you remember, they had to take mug shots. It was a whole big thing. That chapter is closed.
Arthur, what about the Montauk case?
In Martha Nolan's case.
So there you go. And yes, sweet. I take it good says, how much grease is in his hair? Yes. A lot. No Sir San is saying, and this is a good question here. God, my beard is itchy as hell right here in my shin. I have to trim it up tonight. So I can also see, I get that line that forms, and it's always kind of like, yeah, got to fix that because I can see it now. I'm getting a little wing thingies, and like, yeah, can't have that. Can't have that. Look, we're starting to get some buildup. Anyway, he says, is there a chance Fani, if she can, will appeal to SCOTUS and lose there too? I mean, she theoretically could appeal to the but the Supreme Court's going to be like, no. Like that would be a complete embarrassment if she did that. So I'm hoping they're telling her, you're just done. Cut your losses. Take your L, Fani. You know, you are the architect of your own destruction. So let's the saga's pretty much over. The saga is pretty much over at this point. So yeah, I have serious doubts anyone wants to take up this case and put on the clown makeup. Well, they can't afford to do it. Nobody else has got that kind of money. Nobody else has that kind of money, so they can't. So I view this as a bigger L for Jenna Ellis than Fani. Yes, and that's the thing. Remember, guys, those people who fucking pled out, they're still convicted. So that's the problem here. These guys, and we were going to get back to this, but you kind of beat me to the punch. They already pled out. So this is no different than if the rest of them had gone to trial and got not guilties. It doesn't matter. These guys pled out. They're screwed. So, yeah, suffer traitors. The snitches. Yes. Suffer traitors. And these snitches didn't win in the end. No, and guys, remember, it's like they say, nobody talks, everybody walks. Yeah, so they jumped the gun. Yeah. Yep. They bet on the wrong horse. Yep. You know, as the song goes, sell out from me. Oh, yeah, sell out. You know, the record company is giving me lots of money and everything is going to be all right. Ba-da-bum. Ba-da-bum, ba-da-bum, ba-ba-ba-ba. Ba-da-bum-bum, ba-da-bum-bum. Bella says they ran out of money. Yeah, but they could have sat there. But they didn't. They didn't. Trump just posted about this on Twitter. Oh, well, there you go. So, yep, Real Big Fish. It's a good song. It's a good song. So what did Trump put on Twitter? Let's see here. Donald J. Trump. Oh. Let's see here. Oh, yeah, Trump is this is funny. Here, we'll switch to this real quick. It's on Donald J. Trump's.
You go to a cabin. Did you
This is part of the Nathan Wade testimony, which was hilarious.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
I've been really trying,
And this is happening in real time.
trying to hold back and feeling for so long. And this you feel like I feel, baby.
No.
You've never gone to a cabin with this.
No.
Did you go to a
So there you go. But yeah, it's all, that's just watch those people committing perjury on screen was something else. Johnny Osprey says, make ska great again. Yes. And then Bella says, have you heard about the campus death where a black boy was found hanging from a tree in Mississippi? No, I have not heard a word about this. That's weird. Yeah, interesting. So, yeah, he had a very nice suit. Yeah, he took forever to answer that question. Trump did post that. Yeah, I remember when it came out from the official Twitter account. Yeah, it's his fucking official Twitter account, guys. I'm not joking. Look, Donald J. Trump at Real Donald Trump. Yes, the 45th and 47th president of the United States of America, Donald John Trump. Yes. So. Oh, now one white boy and one black boy. Oh boy. So, yes, the reigning, defending, and undisputed impeachment champion of the world, fighting out of the red corner, a business mogul and shit poster, hailing from Queens, New York. Oh. Oh, okay. Yeah, he needs to add the 48 and 49th to cause the meltdowns. It'd be funny if he added 48th, but that doesn't matter. JD Vance is going to be the 48th. Yes. Whisper scream. Oh. Yes. 6'3", 225. Okay, he's a lot more than 225 pounds, but yes. Weighing in. Standing 6 foot, 3 inches tall, weighing in at 225 pounds. Yes. He has been shot, indicted, impeached, and president twice. Absolutely insane. I know. It sounds like he's fucking Teddy Roosevelt when you think about it. It's kind of funny. It's like you're dealing with Teddy Roosevelt. So. So he is now. He wasn't then. Oh no, he's not now. So I'd say 260. I still think he's more than that. As a fat guy, I can tell you he's fat. He's fat. He's fat. But real quick, Vodka Blood for 10 subs. Thank you for the support and your generosity. Oh, Vodka Blood, yes, that thing, that other thing came in for me. Yeah, we'll talk about that later, but I just want to let you know that thing came in. That thing you sent came. Why is this not working? I need to. Is this not working? I can't. Hold on, chat. Well, never mind. I can't get to my. Can't get the stuff here. Snake Plissken says, in summary, the court affirms it's no hose policy. Yes. Brandon, the anime guy, says, ultra combo. Yes. Combo breaker. Yes. The biggest Fanny in Georgia has just been totally on her fanny. We have to be careful because in Britain, fanny means pussy. So I learned that. A while back. Fanny in Britain does not mean the same thing here. May the fanny be forever deflated and disbarred forever. Yeah, it's probably not going to happen though. Just Me says, did you talk about Destiny? I've seen 2 government officials talk about it. And one has him reported to the FBI. Woo, baby, he's fucked. No, nothing's going to happen. Number 1, he's a log cow. And number 2, I don't think he's created incendiary rhetoric where he's inciting imminent lawless action. He's just running his fucking mouth. So, no. Don't think he should be getting charged at this point. But, you know, if he does more retarded shit, that could happen. Brandon, the anime guy, again, thank you. $5 saying, even the Supreme Court in Georgia is full of shit. Kemp is a moron too. Blah. Well, yes, Kemp didn't have the balls to do the right things previously. And then Oh My Ren says Nathan Deal was a longtime member of the United States House. Interesting. Thank you. Before he became governor. Debbie O says for $10. Thank you, Debbie. Harrison Floyd posted today he will refund donations to his defense when they get the funds from the DA. Until that post, I didn't know the DA would have to repay. Yeah, when he can get that money back, he's going to refund it. What a true king. What a true king. Brandon, the anime guy, is a new member. Thank you, Brandon, for your support. I appreciate it. Spoony Samurai says, Fanny was for the sheets, not the streets. Yes. And then Hexy says, stay silent, everyone. A black woman is speaking. And then Hunch the Dirty Roofer says that hairline recedes anymore, and it'll be declared a runway. Yes. She's reaped. She's ratchet. She's weaved. She's reaped. That's why, chat, like, I love this. Maybe I'm tempted to faith, but look, we got all this luscious Southern Mediterranean hair. This ain't Irish hair, I can tell you that much. I think somebody asked me before, like, what am I covering up in this corner? Nothing. It's just, that's the way the hair goes. Also, people are like, you can just do that? And I'm like, yeah, you just comb it a little bit, and it kind of falls like that. So, yeah. There you go. Side, top. There's no reaping here, chat. Thank you, Hunch. And then Kathy, your realtor living in New Jersey. Thank you again, Kathy, for $5. Says, could they have had a hearing about the actual impropriety? That would have been juicy. Well, Judge McAfee determined that it wasn't an actual impropriety, but the appearance. But yes, if he had determined, like, he's like, I know you guys did shit, but he didn't have the balls to do it, but that would have been good to catch him on all that. But remember, in those hearings, we did catch them using their apartments, what they did. We talked all night. I'm sure you talked with his dick in your mouth, Fanny. So I'm sure that's how that went. Oh, gosh. So did Clyde early St. Patrick's Day decoration during his garden party? Oh, yeah. Say, good hair. Thank you. Sean came for the Reaper, yes. Flip it like an emo kid. Hold on. All right, hold on. I'll do that. All right, ready? Probably look like I'm trying to bite my ear. You tell people to bite your ear like, hun. Yeah, it's better when it gets a little longer. It needs to get a little longer for that. I got my hair cut recently, so it's not in perfect condition for that. Eric says, I still have a full head of hair, but I just shaved with a one clip. Oh, no. Hang in there, brother. Hang in there. Yeah, almost got her done. Yes. That's getting clipped. Yes. He's gay! Well, I thought we already established that. I thought we already established it. Pitchluck says, cherish it. I do cherish it. I'm very much happy that I have it. And you know what? Maybe the fates will felt me and take it away from me. Remember that the fates are always looking to fuck with you. That's why you have to stay humble. You have to hold your wrist while biting your ear. Yes. Brandon says, well, hell, I'm out. Have a great night. Well, actually, we're about to land the plane ourselves. So, chat, that is it. That is the saga of Fani Willis. Had she not just been a complete fucking asshole of a human being, probably wouldn't have happened. If she just had a little bit of fucking, being a little humble before God, probably wouldn't have happened. Probably wouldn't have happened. I mean, it is what it is. It is what it is. Yeah, I'm just getting the cul-de-sacs. You're not even sitting on top. Yeah. No, I understand. Sweet Tooth Fairy says, model stream, nope. Nah, not tonight. I am very tired. I didn't sleep last night. I had a lot on my mind that got resolved today. A bunch of shit I got some shit I got to take care of. And today was just like, I was just, in my head, I was this all day. Ah! The whole day. That was as I was getting things done. And by the end of the day, I'm like, ah. So no, I need to get some sleep tonight. I need to get some sleep. So I'm on all stream tonight. It says, Ag says, now what do I do tonight? I don't know. Go murder some co-eds. The flatulence of Fani. Yes. All night. Not tonight. He needs to go sleepy. Yes, I do. Just file that you're not participating since that's a thing. When you're on the Supreme Court when you're on a Supreme Court, you can do whatever the fuck you want and nobody can challenge you. So you get to say, I'm just not doing it. Why? Cause you're like, all right, well, I guess Bob's not doing it. And you're like, there's nothing else you can do there. So drink water and carry on. I just drink. I mean, hell, I drank this whole fucking thing full of water. I'll probably wake up at 3 o'clock in the morning pissing like a racehorse. So don't tell me you have energy. Boy, I could see it on you. I know. I mean, I don't know. Do I look tired, chat? I don't know. Do I look tired? So, can you file I'm eating a sandwich? Yeah. Pure Pants in Bed 2.0 will not like that. So, Smoke and Scan goes live in a half hour. Do I look tired? And you're like, no, you guys look great. No, you just look fat. Your eye bags have bags. Thank you. We need to see the Jimenez reassembled. Well, let me tell you, it's not reassembled. So I've been trying to figure out how to do that. So eye bags are darker. Yes. So you look like a white Cash Patel. I don't know if that's good or bad. I don't know if that's good or bad, Sue. All right, chat. So we are going to wrap this up here. And guys, tomorrow night, we've had way too much serious shit right now. We've had way too much serious stuff. I do want to cover the Stuttering John stuff. I think that's kind of important. We might save that till Friday. I don't know. But the other thing I want to get through is the Michigan electors having their court hearing, because that is available, and I think it's really good to watch and it's necessary. So you guys can see the Michigan electors get their cases thrown out, and the judge handling it. I think it's a really good case to watch. Let's see here. But I was thinking tomorrow night for that, or doing Stuttering John. Because if I do Stuttering John and that, if I do Stuttering John's case, which they have completely surrendered, which is weird. You filed the lawsuit and now you just gave up. But we'll also do a members only tomorrow. And I was thinking about that. Chat. We need a Sex with Hitler game night. We'll work on that. So I was thinking about train models with missing pages all day. There's updates to Smash JT's case. Yeah, there's all kinds of stuff. Smash JT, there's been an update in Destiny's case. Patrick Tomlinson's got stuff I still need to get to. there's all kinds of things to get to, chat. So tomorrow night we're gonna do Stuttering John, and we'll do the members only tomorrow. So that'll be our game plan. That'll be our game plan, chat. And then if you guys are new, remember we do the show Thursday nights 9:30. I don't know exactly what we're gonna do. I've got some stories, but I don't know how much. I gotta figure that out. So but anyways, in the meantime, guys, Greer, no, I'm trying to save the that lolcow stuff for Fridays. I think that's a great night to do it because we can just fuck around. And the lolcow Friday stuff I think is perfect. So Russell Greer doesn't rate prime time billing during the week. So with that said, chat, I am going to land the plane here, and I will see you guys tomorrow afternoon or tomorrow evening. Pending there's nothing insane happening, but the rate the past week is gone. Some kind of shit's going to go down tomorrow. It's 1 week since Charlie Kirk. And guys, remember, please say a prayer for him and his family. It's been a week since all this happened, and yeah, please do. But from there, guys, remember, until next time, just because you did it does not mean you're guilty. But Fani Willis, you fucking lied. So good night, chat. Take care. Wait, why is this not? Hold on, chat. I don't know what the hell is happening here, but okay, now my thing's back. Okay. So anyways, chat, have a great night, and I will see you guys tomorrow.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the